Assalamualaikum. Hi, my name is Muhammad Irwan bin Abakar, PC 251090. I will be acting as lawyer Irwan.
Hi, my name is Faiq bin Rusli, PC 254745, and I will be playing lawyer Faiq.
Hello, my name is Thaanya. My metric number is PC 254632, and I will be playing client Thaanya.
Hi, my name is Alya matrix number BC253991, and I'll be playing as client Sarah.
Hello, good morning. Come inside. So this is my partner, Faiq.
Thank you.
May we offer you guys some drinks?
No, we're good.
Alright.
Thank you for meeting with us.
No problem at all. You guys take a deep breath and tell us what happened from the very beginning.
Okay, so my name is Thaanya, and this is Sarah, my business partner. We run a small catering business together called Thaanya and Sarah Catering. We've been in this business for about 3 years now.
It's a small version, but we've been growing. We do caterings for weddings, events, corporate events, things like that. But these past 2 weeks have been a nightmare for us.
Yeah.
Why? Tell us about it.
So we've got 2 major problems. One with our chicken supplier, which is about business supplies, and the second one is a bit complicated. It is about a van we sold recently, and about a week later, the buyer called us furious.
Okay, we'll take it one by one. Which one do you guys want to start first?
I think we can start with the supplier issue first because it's more straightforward. For the vendor, honestly, I don't even know where to begin.
Alright, Chico first. Tell us everything.
Okay, so we have been buying from this supplier called Ghazali Trading. We've been buying from them for about a year now, and they've been okay, but...
So for this one big event, a corporate lunch for about 200 people, to achieve this, we ordered 100 kilograms of chicken from Ghazali for around 10 per kilogram. The delivery was supposed to be on June 1st before 9 a.m.
So, you guys have the written report? Or it was just a verbal agreement?
Yes, we do have the WhatsApp messages, and he even confirmed our order, the price for our order, and also the delivery date. But it's all in WhatsApp. Does that count?
Yes, WhatsApp messages also count as written contract. The Contract Act 1950 doesn't require a formal document. As long as there's an offer, acceptance, and even consideration, it's a valid contract.
Thank God, so we do have proof.
Yes, you guys have proof. Keep those WhatsApp messages. I recommend you guys screenshot them, save them in a folder. Don't delete anything.
Understood. Okay, we take note of that. So on 1st June, we were waiting since 8 a.m. for the chicken, and then 10 a.m. still nothing, and they only arrived at 11 a.m. but only with 60 kg of chicken.
I called the supplier immediately. I was so furious. I asked the supplier, where's the remaining 40 kg? And the supplier replied to me. He said, take it or leave it. He cannot deliver the remaining 40 kg because they ran out of stock.
Did he give any reason, like any apology?
No apology at all, nothing. He just said take it or leave it like you were begging him or something.
Did you take the 60 kg?
We had to go. We had a corporate event and had to feed 200 people. If there was no chicken, then no business. And if we didn't deliver what we promised, then our reputation would be lost.
And catering is all about reputation. One bad review and we're done.
So you took the 60 kg, then what happened to the remaining 40 kg?
We panicked. I'm not even exaggerating. I was running around like crazy.
I must have called 10 different suppliers. Everyone was either out of stock or they were charging really crazy prices, and finally we found one, but they charged us 15 ringgit per kg.
And that is 5 ringgit extra per kilogram. And for 40 kilograms, it came up to 200 ringgit. And we have the receipts as well. We learned to document everything after a few bad experiences.
The receipt, good. Keep the receipts. Hold on to it. That's your evidence.
Here's our question. Can we claim that 200 ringgit? And maybe something about this trust? Because to be honest, I was almost I almost had a panic attack that day.
We did.
Okay, so from what I've heard from you guys, the issue here is whether Mega Jaya Trading breached the contract by failing to deliver the remaining 40 kg of the chicken, and whether Thaanya and Sarah Catering are entitled to claim the additional 200 ringgit incurred in purchasing of the replacement of the chicken.
Okay, let me answer one by one. First, under contract 1950, you definitely had a valid contract. Section 2, subsection A, talk about offer. Mega Giant offered to sell you 100 kg of chicken at 10 ringgit per kg. So you accepted it. And section 2, subsection D, talks about consideration that you promised to pay what they promised to deliver. So yes, valid contract.
And under the section 40 of the same act, when a party refuses to perform their promises, like Mega Jaya refused to send you guys the 40 kg, that's a breach of contract. You have the right to claim any damages.
What kind of damages though? That's what we really want to know.
Under section 74 of the Contract Act, you can claim compensation for any loss that naturally came from the breach. Your extra 200 ringgit, that's very natural. You have to buy replacement chicken at a higher price, so that's a direct loss for you.
What about the stress we faced, the panic, and the fact that we almost lost a major client? Can we claim for that as well?
I hear you guys, but under section 74, compensation cannot be given for remote or direct loss. Stress, anxiety, or reputational damage, the law considers those too remote, unless you specifically told Mega Jaya before the contract that failure to deliver would cause a specific harm.
So we cannot claim anything for the sleepless nights?
Unfortunately, no. The law is quite strict with it.
Okay, so I understand. Just the 200 ringgit then?
Yes, and there is a Malaysian case that supports this. The established by law developed in the case of Irwan and others versus Nachumanan, the effect of failure to perform obligation with a specific date. And where time is of the essence, the court held that such failure constituted a breach of condition of the sale agreement. Also, in the other case of Thaanya versus Associated Metals Motors Limited, where the defendant sold a furnace that didn't work as promised. So the court allowed the buyer to claim extra costs because they were directly caused by the breach. And that's exactly the same situation of yours.
So does that mean that our 200 ringgit is safe and we can definitely claim that?
Yes, 200 ringgit is the strongest claim. It's clean, it's direct, and you have the receipts. No courts will deny you that.
Okay, so that is a very big relief. So what do we do next? Do we call them? Do we send a letter? Or do we have to go to the court immediately?
No, don't go to court yet. Instead, just send them a letter of demand.
Okay, so we will send them the letter and hopefully they will just pay us and we don't have to go to the court.
Yeah, thank you for helping us with this. And okay, this is one problem down. And now the van.
Okay, can you guys please explain it?
Okay, so when we started our catering business 3 years ago, we needed a van to do the deliveries. So we went to a second-hand car dealer and bought a Toyota Hiace. The dealer said it was a 2018 model and we believed him.
We use it for 3 years now. We use it every day to deliver goods and such, and there were no major problems. And last month we decided to upgrade, so we advertised it as a 2018 Toyota Hiace, and this guy named Ravi bought it from us for 25,000 ringgit.
Did you guys even inspected it before selling?
No, it was running just fine. So we don't think we should waste money on inspection.
And then a week later, Ravi calls us screaming. He took the van to a mechanic and it turns out the front half of the van is a 2018 model, but the rear half was 2012. It was welded together after an accident, it seems.
We had no idea it was welded together because we are caterers, not mechanics. And we really bought the van in good faith.
I believe you guys, but here's the issue. Whether you guys are liable for breaching the implied condition as to sale by distribution under Sales of Goods Act for selling the reconstructed van, and whether Ravi is entitled for the damages or full refund. So according to under section 15 of Sales of Goods Act, when you sell a goods by its distribution, like in this case, the 2018 Toyota Hiace, there's an implied condition that the good must match that description.
So even though we didn't know we are responsible,
Yes, based on the case of Narcoticas Bosha Thomas and Company versus Misu Busan Malaysia Limited, sales of goods must comply with the description you provided. In this case, the buyer bought flour, but the seller delivered flour with a different trademark. Even though the flour was good quality, but it still doesn't match the description. There's also a famous case called Bill versus Taylor, where a guy sold a car as 1961 Herald. Turned out the flour was from 1961. Real from our older model welded together. The seller genuinely didn't know about it. Family, right? So, but the court still held him liable.
That's exactly our situation. So what does Ravi get?
So there's two options. The number one is you reject the ban and demand the full demand of 25,000 ringgit.
we cannot do that. We already used the money to buy a new van.
Yeah.
Okay, so another option, which you keep the ban and claim the damages. The difference in value, a genuine 2018 van is worth around 25,000 ringgit. A welded hybrid maybe around 15,000 ringgit. So the difference is around 10,000 ringgit.
So it means that you could claim the 10,000 ringgit from us.
Yes, but because you're not a car dealers and also not generally they know about it, and court might reduce it. So I recommend you guys to offer 8,000 ringgit as a settlement.
What if he refuses and demands the full 25,000 ringgit back?
Then I suggest you guys to negotiate it under, like the case the one mentioned before, under Bill versus Taylor. He's only entitled to the difference, not a full refund. Don't go above 10,000.
Will we need this in writing?
100%. Get him to sign a settlement agreement saying that 8,000 ringgit is full and final. No signature, no payment.
Can you help us drop that?
Yes.
We will send you the letter of demand for Megah Jaya and the settlement agreement for Ravi by email. No extra charge.
Now let us summarize everything so you have clear next steps.
Alright, so firstly is Megah Jaya Trading. They breached the contract under Section 40 of the Contracts Act 1950. Claim 200 ringgit under Section 74. Send letter of demand, give them around 40 days. If no payment, small claim costs. Then, for the second one, Ravi and the delivery ban. Under Section 15 of Sales of Goods Act and Bill versus Taylor, you guys are liable. Offer around 8,000 ringgit partial refund. Not a full refund, maximum around 10,000 ringgit. If he negotiates, get everything in writing. Have him sign before you pay.
So just to confirm, claim back 200 ringgit from Megah Jaya and offer 8,000 ringgit to Ravi.
Correct. And I suggest for the future, whenever you want to sell vehicles or equipment, get them checked first. Or put them as sold as is in your sale agreement. That way it can protect you a lot from any problems.
Definitely will do. Lesson learned now. We can trust but verify. Also to document everything.
Exactly. And then if anything changes, like let's say Ravi get aggressive or Megah Jaya refuses to pay, call us immediately. Don't handle it alone.
Thank you so much, Irwan, and thank you so much, Faiq. We feel so much better now. It's going to take for the past few days.
You're welcome. That's what we're here for. We'll send those documents by email within 2 days.
Thank you, and we wait for them. And we also let you know what happens with both situations.
Please do, and good luck for you guys. Take care of yourself. Also, your business.
Thanks again. We really appreciate your help.
Anytime.
Right.
Bye for now.
Thank you.
Yeah,